Yes.
I was just saying, when the defendant was out, that matter.
Okay. Well, yeah, you can bring him up. What is it?
Your Honor, on the notice that the state filed to seek imprisonment for life without the possibility of parole, based upon the jury's verdict in count 1, the state would move to basically strike our number 3 and what would be in the code section number 16, because that requires an intentional.
As to
The murder was committed against a pregnant woman.
Right.
And the defendant intentionally killed the victim. The jury's verdict of a knowing killing, I think, removes that as an aggravated
from what would be, if it had been instructed at all, in count 3. Right.
Yes, sir.
Okay.
Yes, sir.
All right, so that wouldn't be, all right, now, any submission, Mr. Brand, Ms. Harris, on the mitigating circumstances?
Yes, Your Honor. As far as mitigating circumstances, and I've discussed this with Mr. Moore, we would submit that the mitigating circumstances in section J1, that the defendant had no significant criminal history, would be appropriate in this case. My understanding is there's no objection to that.
Okay,
That's correct, Your Honor.
And then, I apologize, I don't know which number this is, but the catch-all provision that
number
any other,
10,
yes, number 10, any other circumstance essentially fairly raised by the proof in this case.
does the state care to be heard on that?
Judge, submit under the law that has to be specific as to what that is, like a list of that the defendant graduated top of his class and those sorts of things.
Sure,
not just a catch-all.
Right, and so to specify, we would intend to put on proof related to Mr. Taylor's education, his high performance in school, his high performance in athletics.
You would?
We are going to.
Okay.
Yes, we are going to put on that proof today at today's
Okay.
hearing. His involvement in nonprofits, so community involvement, other essentially positive personal traits and background related to Mr. Taylor that would support mitigation.
Okay. All right, I guess we can discuss the language of the court would place in there once we hear the proof. Anything else before the jury's brought down?
No, Your Honor.
You
Statement
give
intended
opening
to-
statements
A
and,
brief, yes, Your Honor.
okay.
And we would as well, the state.
Okay. And does the state, just again for court's edification, know how many witnesses you may be calling?
3.
Okay. All right, let the jury step down. But General Moore, the states, are you in agreement that the jury would be instructed in terms, well, I can ask this later. It dealt with victim impact statement not being an aggravated circumstance.
Certainly.
Yeah.
And the jury can only consider that after they have found the existence of at least one aggravating circumstance.
And just before we get into an issue, the victim impact statements are not going to include any statement of what they want. to
No,
happen.
no, we've discussed that.
Okay. Or you can have a seat. All right, members of the jury, when we get to this portion of this particular trial, the law allows for the attorneys to give to you opening statements, then present proof, and I'll explain all this in the jury instructions. The parties are allowed to introduce appropriate, relevant proof to the issues for your determination in terms of the penalty that the state's seeking of life without parole, or whether it should be a life sentence imposed on the counts 2, 3, and 4 that you've rendered the verdict on. Right. Does the state care to make an opening statement?
Yes, Your Honor. Just briefly. Members of the jury, because of your verdict, we are now going into the second phase of this trial. And what the state will present is based upon, like it seems long ago that I read the indictment. In this part of the proceeding, the state relies upon aggravating circumstances that are named. And there are 2 of those presented for your consideration. Number 1, the murder was committed against a person less than 12 years of age, and the defendant was 18 years of age or older. Say referring to Ivy. Number 2, the murder was knowingly committed, solicited, directed, or aided by the defendant while the defendant had a substantial role in committing or attempting to commit, or was fleeing after having a substantial role in committing or attempting to commit any first-degree murder. Again, based upon your verdict. The existence of those circumstances have been found beyond a reasonable doubt by your verdict. That allows, at this point in the proceedings, for the state to present what under the law is called victim impact testimony, to give you a view into what Jade and Ivy's death, the effect it has had upon her family, her extended family, and not going into really anything else. It's limited to that. Victim impact. And we'll be calling 3 witnesses. Jade's aunt, Brady Moran, and who would have been Ivy's great aunt, Andrea Browning, who you heard before, and Jade's mother and Ivy's grandmother, Bridget Burks. At the conclusion of that testimony, and whatever the defendant chooses to present anything, this is what this is proceeding, that is submitted to your discretion. The judge will tell you the law, and once we conclude the proof, there'll be opening argument of the state. Perhaps the defense would have a chance, or they will have a chance to make an argument, and the state would close. Again, because we have the burden of proof throughout the criminal trial. But that is the process, and that is what you will hear in this part of the proceedings, to allow you to, in your discretion, determine what the punishment should be for the 3 first-degree murder cases. Thank you. Thank you, Your Honor.
All right, any opening statement?
Thank you. This case is and always has been tragic. Nothing that anybody's going to say in this relatively short portion of the trial is going to change that. And the thing we are going to ask you to remember is, even if you find there's aggravating circumstances, and really the aggravating circumstances the state is going to ask you to find are based on your conviction. Mr. Taylor's been convicted, there's no question. It doesn't require you to give him the harshest penalty ever. He's going to prison no matter what. The best outcome today is the rest of his life in prison, 60 years in prison, with maybe in 51 years he goes up for parole. He's 30 years now. At 80 he goes up for parole. That's the best outcome for today.
You don't have to give him life without the possibility of parole. You can give him the opportunity to try for rehabilitation. You can give him the opportunity to work hard in prison. He's not going anywhere. This is a tragic case, but it doesn't have to be the worst of the worst outcome. Thank you.
Great. Who's the state wanting to call?
Your Honor, the state's first witness would be Ms. Brandy Moran, and as part of the proof in this portion of the proceedings, the state would ask the jury to incorporate all of the